Welcome to Two Angry Men, the newest podcast with Los Angeles Magazine's own Mark Geragos and TMZ's Harvey Levin, where the two get together and talk about the biggest legal stories of the day. Enjoy.
I'm really fascinated by this racketeering charge. I mean, having a three-way in a hotel room is not typically what you think of when you think of racketeering.
It really is a slippery slope. I just think people's sex lives are off limits.
Welcome to the Two Angry Men podcast. First, my apologies, Mark, that I was torn apart by some of the people listening because I interrupted you when you wanted to give lessons in the law, so mea culpa.
Well, for those who don't know what we're referring to, every time I tried to explain what we were talking about and give some kind of law, I don't want to say rudely, because you're never rude to me. You're always very kind. But I was cut off. And you did get, to your credit for recognizing it, the listeners savaged you.
Wait a minute. To my credit?
Yes.
You sent me those comments.
Well,
you texted them to me all weekend.
I was inundated by them.
Oh,
I was inundated by people who were saying, would Harvey just calm down? We actually, Harvey, a cynic might say that you really are kind of a variation of H.L. Mencken. Do you remember who H.L. Mencken is?
Of course I remember H.L. Mencken.
Okay. H.L. Mencken, one of his famous sayings is, you'll never go broke underestimating the intelligence of the whatever. So I don't have that belief. I believe that people, when they listen to a show with two lawyers, want to actually hear about the law. So I default to that, and I have very high expectations. In fact, I will tell you, historically, doing podcasts and things, I have learned quite a bit from people's comments, both it's almost like a focus group. Sometimes people give me arguments or comments. A lot of times they're rude, but sometimes there's some very valuable insights.
Okay. Well, look, the fact is you were deflecting what I really wanted to talk about, but that's okay.
Oh,
I
wasn't deflecting.
Okay.
Let me explain.
No. Can we get into?
Oh no! Here we go again.
Can't we get into Diddy?
As soon as I want to talk.
Oh no! What? Can we talk Diddy for a minute? Everybody
No,
wants to.
We're going to talk. By the way, I'm 96 hours removed, 72 hours removed. I have a bone to pick with you, as usual. 72 hours removed from Judge Jessic, who is a Superior Court judge in L.A., who was the judge presiding over the Menendez brothers. A monumental day for the family, for the Menendez brothers and their family. Monumental. Across the board, anybody who witnessed it thought it was monumental. You then go on to our local Fox affiliate here, Fox 11, and with a mutual friend of ours, and Alec Michelson, and you proceed to minimize it and say that what was accomplished was basically nothing, all form, no substance, blah, blah, blah. I listened, and then you sent it to me and said, look what I said. And I watched it and I said, you're like wrong on every point.
What's funny is we had a private conversation. As long as you're going to do this, we had a private conversation days before. I have
not revealed the private conversation.
Well, I'm going to, because you just said I was all wrong.
Whatever happened to confidentiality and friend?
You just blew it because you agreed with me.
Wait, no.
Yes.
This is what I said to you. Let's call this out.
Well, we should explain what we're talking about. So what I said was, look, the judge resentenced the Menendez brothers to 50 years to life rather than a life without parole, and that it triggers a parole board hearing, essentially. My point was, it's already at the parole board because the governor already sent it there. And functionally, it's the same thing, that the governor is going to get this on his desk from the parole board, whether it's a hearing or a clemency petition. And we know what the governor's going to do. He's looking for two elements. He's looking for rehabilitation and whether they're a danger to society. And if they jump both hurdles, I think the governor's going to let him out. And it doesn't matter whether it's resentencing or clemency. That was my point. You agreed with me on that days before.
No, I actually told you why you were wrong. And I will explain it now if you won't interrupt me. What you said conceptually is, for somebody who doesn't understand what's happening, it seems to make sense. This is why it doesn't. The governor set it for a clemency hearing on June 13th. That clemency hearing would have, the basic was risk of public safety. He wanted a recommendation. By the way, if Judge Jessic had not done what he did, which was resentence them, basically strike the special circumstance, which makes them immediately eligible for parole because they're youth offenders. If he had not done that, they still would have had a clemency hearing on June 13th and then would have made a recommendation. And then the governor could have said, hey, I'm going to reduce it to 50 to life and let the parole board do something.
But he could have
That's
also
what he could have done.
But he also could have said,
are you going to let me finish?
Well, wait a minute. But am I right? I understand.
Yes, he could have.
That he also could have released him.
Correct. But that's historically and past his prologue, you look to what he does. He frequently in the past has done exactly what I'm talking about. He will say, if somebody will make a clemency application, he then commutes from life without to 50 to life. The reason he does that, and as we explained at the resentencing hearing, is correctional officers, I always say this, they're some of the people who are greatest advocates for this. Why? Because they want people to aspire to be good, to change, to behave themselves, and to have real insight. So he does that so that he rewards people for taking those actions. He has done that historically. Now, the proof that I think I was right was the day after, meaning yesterday, the judge had commuted basically his own, resentenced to 50 to life. The governor then took that June 13th hearing and he converted it to a parole hearing. So now the governor is more likely on a bell curve of options, given his history, more likely to let them out. So that's my point.
Fair. And I could easily argue that point, but I'm going to take an L so we can talk about Diddy. Okay. So Cassie has testified most of the week. My opinion is, before we get into who won and who lost here, is that she really came off as truthful, that there were warts in her story that were not flattering to her, not helpful to the prosecution, but she told them. And by doing that, the testimony that really does hurt Diddy becomes more believable because of her demeanor, because of what she said, because she was open about things that were clearly pro-defense in some ways.
Well, I will quote her lawyer, Doug Wigdor, who said the facts are the facts and the texts are the text. And I have not read a transcript of what's been going on today. And I know you said, maybe you have, because you obviously your newsroom is keeping up. But I always say there's no way to judge what the truth is until you've seen all of the direct and all of the cross. Because the ESPN model, what I call the ESPN model, which is trying to judge it in real time, it is helpful. It's instructive, kind of like calling play-by-play or color for a game. But ultimately, at the end of the day, you really have to wait until all of the cross is done. I'll give you a couple of examples.
It's done. It's done. They've finished cross.
So, and your takeaway?
My takeaway is that she was honest. That I think that, was she going to pull back from, leading a swinger's lifestyle? She didn't. Was she going to talk about her jealousy? She did. Was she going to talk about the fact that she went back to him repeatedly? She did. She talked about things that clearly didn't benefit the prosecution and things that did. And I think when people do that, they just become generally more believable.
I agree. But remember, if there are things, you get an instruction, the definition of reasonable doubt in most jurisdictions, and you'll have it there, I'm sure, jurors are going to be instructed. If there are two reasonable interpretations, one that points towards guilt, one that points towards innocence, they don't have to be equal. As long as they're reasonable, guess what?
I get it. So
the defense wins if that's the case. And by the way, I still think that the judge instructs jurors, and you know this better than anybody, obviously. Judge says you can't, and by the way, I think intuitively it's just totally counterintuitive. Judge will tell, and he instructs people, the jurors, the panel, everything else constantly in every trial. You can't make up your mind until you've heard all of the evidence. You can't decide. And that is so, because I've had this argument for years with other trial lawyers. Are the jurors' minds made up as soon as you select them? Are they made up, right after opening statements? I personally believe, there was, you remember Jerry Spence when Jerry was still practicing. Jerry used to forcefully argue that 90% of the jurors' minds are made up after opening statement. I take it back before that. I think the game is over in jury selection, absent some kind of aha Perry Mason moment during the trial, and absent, poor lawyering. I think once you've selected the jury, that you cannot, even in a long trial, 8 weeks, you can't change somebody's prism. You can't change somebody's outlook. You're never going to convince them of something that they just come and look at the facts through. So I just say, wait until you hear all the evidence. Don't make a decision yet. And though there are quite a few turns and twists and bumps between now and then, I think that you just have to wait. I think that so far, you tell me, so far, aren't you somewhat surprised about how this has unfolded?
I am surprised, and I'll kind of give you my take on this, that
Please.
I have seen both the prosecution and the defense try to kind of draw a completed circle in various areas, on extortion, on motivations for things, and they never close the loop. I've seen so many times on both sides, they just didn't close the loop where they made their point, and it really surprised me. I mean, there's one piece of testimony that I remember where they read text where Diddy said to Cassie, "Do you want to do a freak off?" Her answer was, "I'm ovulating." And that means no intercourse, clearly. And then Diddy says, "Well, can we kiss?" And she said, "Yes." So they do a freak off, and it lasts more than 10 hours. But nobody says, what happened during the freak off? Did they have intercourse? Was this a ruse to get her in? Nobody knows. And those loops were not closed throughout. But the thing I want to ask you about that.
Can I comment on that?
Yeah,
Because
for sure.
I think the reason, and to some degree, it's just because of the way your mind is trained. You want to get there. You want to get to an answer. You want that. I think that a lot of times lawyers, and somebody who used to work for you a zillion years ago, a reporter, once told me this. They said, they had watched me do a cross-examination. You said it's like a cat with a ball or a mouse, or kind of just flipping around. You never closed it. And I told her at the time, part of the reason for that is it's always drilled into you. Never ask a question that you don't know the answer to, or think that you boxed the witness in so that they have to answer it. And I think that there is an element of that in every trial. I know a lot of times, if I think that the points that are being made are susceptible, once again, to the two reasonable interpretations, if I think that my opponent, if it's a criminal case as a prosecutor, is not going to ask that question at all, to your point, that closes the loop, I'm not going to do it. And you know why? I'm going to circle back to that in the closing statement, and I'm going to say, they could have asked. They could have said, they could have had the witness answer the question. They didn't. You know why? Because they too have reasonable doubt as to what the answer is. And that gives you, ladies and gentlemen, the reasonable doubt.
Well, sometimes it's self-inflicted, because there was one instance where the prosecution was asking Cassie about an incident in Cannes where Diddy suspected her of stealing drugs from him, and
of her stealing
drugs from him, threatened to release freak-off videos, and then they flew back to L.A., and they were sitting next to each other. He showed her the freak-off videos and then threatened to release them. And then she says, well, then the next day we went to dinner, And and during dinner, he said, "You want to have a freak off?" And she said, "Yes." And the prosecutor said, "Well, why did you say yes?" And she said, "Because I was afraid he'd threaten me." Well, what they never connected was the threat on the plane to the freak off. And it's like, why didn't you close that? So maybe you're right that they couldn't, but guess what they did today on redirect? Because we made a big point of it on TMZ that they never closed that loop. Guess what they did today? They closed the loop. They asked her the question on redirect and said, "Did he threaten you specifically on the freak off?" And she said yes. So it was like, why didn't they just ask that then? It's almost they did cleanup. And I've just seen that a bunch on both sides. That's what I'm saying.
Redirect, the whole purpose of redirect, whether you're on, it's on the defense side or the prosecution side. I'll talk about this week in Menendez. There were a number of times with witnesses where the DA, Habib Balian, who I have a great deal of affection for. I think he's got a lot of game, even though I'm sure the family and my clients weren't fans. But I always appreciate the skill set of a adversary, and he's got skill. And he did some damage, I thought, or I perceived, on one of the witnesses. So I get up in the redirect, because obviously we're putting on the witnesses, and do cleanup, and was able, I think, to effectively clean up some of this stuff. That's the ping pong match. That's the give and take when you're a trial lawyer. Because, and to your point again, or to answer your question again, there a lot of times, and the problem with it's not a problem really, it's just the crux of a case that's circumstantial. Because remember, to some degree, everything here is circumstantial, or a lot of it, because it's all intent. And the way you prove intent is the facts that come out, and then you have to infer the intent. And if there are two reasonable interpretations of why somebody did something, you sometimes don't want to foreclose the one that benefits you from being argued. And that's the calculation.
I love you said that, because that's what I want to get into. Exactly that, the reasonable interpretation. I think the defense screwed something up really, really bad today.
Tell me.
Today on cross-examination, they got into the video at the Intercontinental Hotel, the 2016 beating that we see on videotape. And they showed, first of all, they showed texts that Cassie sent Diddy right after the beating, the day after the beating, saying, "You treated me like a rag doll." And it was very emotional. And then they show another text where they move on and, LOL, eventually do another freak off. Well, number one, to me, and I just want to make my point here generally, that's called Stockholm Syndrome, where somebody can get beaten and then they do it again. So I think jurors are sophisticated enough to understand that, because somebody forgives doesn't mean it didn't happen, number one. But the almost bigger thing, I talked to Mark Agnifilo on one of our documentaries, a couple of months ago.
Mark is the lead lawyer for the defense.
Right.
Those who aren't in the lead.
And I asked him about the Diddy video, and he said that, we are going to be harder on Diddy than the prosecution is. It's unforgivable. It is disgusting. And it is not the person he is generally. So, okay, that's your argument. Today, they start bringing up to Cassie, did you know anything about him possibly being bipolar? Did he have a blackout? That's called an excuse. And I think it is a huge misstep, because, they're trying to make the argument that the beating in the hallway doesn't connect to the charges. But the jury is seeing this, and it's incendiary. And to start making excuses for it, as opposed to what I thought Mark was going to do, I thought was a blunder.
Well, like I said before, I would wait. Publicly filed documents suggest you're only a quarter of the way there. So I would suggest patience, and then see how it's all tied together. I could prognosticate. I don't want to get in the way. But once again, to my point, you're always talking about intent. And, the idea of intent and the idea of what the actual decision is. Remember, one of the things that you explain to jurors when you're picking them, at least I do, is, and here there was no attorney voir dire, but in a lot of cases there is where I can address them. You explain to them, the judge over there, the guy wearing the black robe, he gets to tell you what the law is. But the jurors, they're the ultimate arbiters of what the facts are. They get to determine the facts. And then the judge gives them the law, they apply the facts to the law. That application of the facts to the law is exactly where the playground you're in right now. And I think if they're doing their job, and I trust they do, because jurors generally are very conscientious, I think they listen to the judge. I don't think jurors, for instance, are watching our podcast because they're told don't do media.
Please, you don't think they're looking at the media? They open their Facebook page and they see their feed? Come on.
Well, there is that's a whole different discussion.
It's a big discussion
about sequestration, right? I mean, we could talk about that. That's a whole different discussion. But what I'm saying is, or the point I'm trying to make is, if they're doing what they're told to do, and jurors are very conscientious, if they're doing it, if they are instructed that you can only apply these facts to this kind of situation to make a determination on this law, the defense has an argument there. The prosecution's going to argue one way, and the defense is going to argue the other. We're not there yet. We are. What are we? 1 week in of trial.
She is a really important witness, though. She is a star witness.
Right, but quoter lawyer again. Facts are facts. The texts are the texts. Remember, you're looking at stuff that happened 9 years ago. So they're reconstructing things that happened between 9 and 20 years ago with a prism of looking at it today. Everybody is a different person. At least I know I am, and I'm sure you are, today in 2025 than you were in 2004 or that you were in 2016. And what you may be appalled by, what you may look upon either fondly or negatively 9 or 10 years ago, is not the same as what was happening in real time. And I think that's what Cassie's lawyer was saying. I think Wigdor was saying, you have to understand it was real time. These are the texts in real time. And that's what you have to do. You can't, after the fact, the whole idea of, a retroactive, the law has a very precise idea of retroactively looking at stuff. You can't make, for instance, you can't say something's a crime today that wasn't a crime 10 years ago. You can't retroactively apply the law. Well, to some degree, that goes with the facts. You can't retroactively revisit the facts or revise the facts. You have to.
That's the whole premise of cancel culture.
Yeah, that's exactly right, by the way. Exactly right. That's a great point. By the way, Harvey, I'm going to give you a shout out. It's like the 5th time in the last 3 days that we've had the exact same thoughts.
I know, it's weird. It's weird. It's troubling.
Very.
Help me out on something. Something came out today, and I am just fascinated by this, and I don't understand it. It just came out that Cassie got a settlement from the Intercontinental Hotel where the beating happened in 2016 for $10 million. And I'm trying
Wow, I was going to ask you, I was literally walking here 45 seconds before I sat down. Somebody told me that. I did not know that.
I didn't know it either. And I'm trying to think, where is the liability? Because when the security guard came up, it was already kind of over. So it wasn't so much not stepping in. Could it have been not filing a police report? Could it have been, I don't know what it could have been, but I don't understand where the Intercontinental's liability is. I was just fascinated by that.
I like I said, I was stunned when I heard it, and I just walked down here. So I'm going to read the transcript.
It didn't say. It didn't say. I mean, they never said why. They just
has anybody asked the lawyer?
Not that I know of. That's why I'm asking you. I thought
like
you'd
I said,
know.
you knew before I knew. I'm telling you, I was asked on the street before I came upstairs by an associate, not even a friend, somebody who I know, who said it, and I said I've never heard that
Yeah, no,
before.
I had no idea. I want to get into this.
By the way, ironically, the Intercontinental is not there
Right.
anymore. The Intercontinental is 50 feet across the street from where I'm sitting right here, maybe 50 yards. So,
Downtown.
yeah, downtown LA.
Yeah. So, I'm really fascinated by this racketeering charge because generally, we've talked about this, it's an organization that's charged or a group of people, and this is one guy. And I'm trying to figure out, it seems like they're trying to use, because the Kid Cudi, if they could prove that Diddy got some goons to, blow up Kid Cudi's car, that would be an element of racketeering, I would think, or hanging somebody over a balcony, to get something out of them. I could see all of that, but it seems like the defense, or that like the prosecutors, are trying to create a racketeering charge around the freak-offs. That he got somebody to book the hotel room, and I just thought, God, for racketeering, when people think mafia, that seems like a stretch.
Isn't it funny how if you were to do free association, it's so funny you say that, and I'm really starting to worry about the mind melt. But when you do free association and you say the word racketeering, immediately you say mob or mafia. I mean,
Right.
it's a default.
Right. So am I wrong here that, I mean, ultimately, so somebody books a hotel room and he hires an escort. Well, there's already a crime for hiring the escort and crossing state lines for commercial purposes. So that's already on the table. But to then say, and on top of that, it's racketeering, having a three-way in a hotel room is not typically what you think of when you think of racketeering. And that's
By
where.
the way, is there anything about, I don't know about you, but is there anything about, I was kidding somebody yesterday that I called him and he did not recoil, a rock ribbed Republican. I said, as a rock ribbed Republican, I'm old enough to remember when you wanted the government to stay out of your bedroom and or hotel room. I recoil against this idea of the getting inside of the hotel room or the bedroom. And I mean, that was the whole idea of the U.S. Supreme Court cases outlawing or that challenged the outlawing of
Griswold versus Connecticut.
Yeah.
Yeah.
I mean, this whole it really is a slippery slope when you start introducing people's sex lives into situations. I mean,
is that going to be an argument? Is that going to be something that your daughter, who is on the defense team, might make in closing argument to the jury?
I don't know how the prosecution and the defense can avoid that. Don't you think, just like when you think racketeering mob or freak off's bedroom or sex, because I mean, what a freak off is sex. How do you not address the elephant in the room, so to speak? I mean, I think theoretically, I would think you would have to, and I can imagine if I had to do both sides of that argument. I know what the argument is. The government's going to say no, this is part of a pattern. The defense is going to say stay out of my bedroom.
See, I see a distinction between racketeering and the Mann Act, the interstate commerce of a prostitute for commercial purposes. I think they could say, because it's funny, because we did a mock jury for one of the Tubi specials, and that jury, unprompted, went right to this. They had real problems with racketeering for the reasons you're talking about. They didn't have a problem with the Mann Act because they said, by the book, he did it. And so they all voted guilty on the Mann Act. They were split even on the racketeering. So and I see that happening.
I have a friend who was just saying yesterday, a lawyer, a very close friend of mine, Big Boy, so I call him. Big Boy was saying, it gives me the willies on this Mann Act. He says, every time I take a girl to the Burbank airport and I fly her to Vegas, am I violating the Mann Act? I said, it is a slippery slope, and that's baby oil, pun intended.
Well, did you ask him, is he taking the girl or paying the girl?
Well, by the way, this is eerie. I did say that. I said, when you take her to dinner, is that the payment? Or when you take her to a show, is that the payment? When you hand her some chips to gamble with, is that the payment? I said, if that's the payment, Burbank Airport, I've been there on Friday afternoon. It's filled with sex traffickers.
That is hilarious. Okay. Let's talk urine for a minute, because Nancy Grace.
Oh my God!
Nancy
Grace
really
going to go there?
Yeah, because Nancy's head exploded. Mark and I, just so you guys know, we do a weekly show on Tubi, kind of a roundup of the case, and Mark is there along with Nancy, and boy, she went nuts on you because what Cassie said was that she was in the room with during a freak off with Diddy and a sex worker, and both Diddy and the sex worker urinated in her mouth to the point she started choking. And the issue came up, did she say no? And Nancy, that was kind of your point, and Nancy is like, isn't it obvious that she didn't want that? And you guys went back and forth with no resolution. Nancy isn't here, so your point is?
My point is, I don't want to get into or be judgmental about people's sex lives. It's uncomfortable for me. I'm too old for it, but I don't know. I mean, I can think of, and I've had a zillion cases that I've defended where people are into stuff that is not illegal, that I would never engage with. So I just think people's as we sit here in California, Harvey, unlike the U.S. Constitution, in the California Constitution, we have an absolute right to privacy. We don't have that in the U.S. Constitution anymore, but we do in California. And I've always said, thank God, I don't want anybody in the bedroom or in the hotel room with me, and I certainly don't want to be in theirs. So Nancy can say what Nancy wants, and I get it. Different strokes for different folks. I don't even want to make the usual jokes that I would make, because I just think people's sex lives are off limits.
Well, that's what this case is about.
Yeah, I know. I get it. And it's just one of the things that's astonishing to me, and has been astonishing to me all along. I just don't know. I don't understand the kind of intellectual compartmentalization of somebody who is, recoils at the idea of the government in their sex life, in their room, so to speak, literally in their room, and at the same time saying, okay, I want to talk about, and I want to demonize, and I want to go there on everything else. I just, the whole thing strikes me as rather un-American and unconstitutional at some level.
So I will not give out secrets, and Mark and I have known each other for many, many years, and a lot of it has just been professional, where I was a reporter at CBS in LA and covered a lot of his cases, and we became friendly and we would talk off the record, and I'm not going to say anything specific, but we've had talks over the years where, each week you've kind of had a feel for how's it going. And I know the lawyers talk about how's it going. I'm working on a story, so sorry about that. Okay. So, sometimes, you just kind of look at the end of the week and you say, we're kind of in a hole. We got to dig out, or we did really well this week. Who did well this week?
Well, I haven't read today's transcript. When I get my New York Times alert, I'll read it. The
TMZ alert isn't good enough for you, huh?
I do follow TMZ. So, but by the way, to that point, how many times, and it's always usually me, so I will take the brunt of this. How many times have we gotten into heated conversations over the years?
Oh my God. Oh, I can't count that high.
I remember one time I was in a hotel in New York City, not in my hotel room, but in the lobby. And I was asked to leave the lobby because I was yelling so loud at you. And I don't remember the case, but I vividly remember screaming at you as I was, and it was more than 10 years ago. And I was asked to leave the hotel. I think it was the old Plaza Athenae and up
In
on
New
the
York.
Upper East Side.
Right.
Yeah. And they asked me to step outside because I was screaming so loud at the top of my
And you
lungs.
do know, by the way, it was always a one-way street. I never did that to you. You
I
always did
will
that to me.
give you, I will give you this. You always have maintained a very even keel in our heated conversations, even when I would have
Except last week.
expected. Yeah, exactly. Except last week. Actually, I won't even tell the other story about 2 days ago. 2 days ago, you and another friend of mine were at odds, and that was something as well. Jesus.
I don't even remember that. Okay, so winners and losers this week. What do you think?
I would give if I'm going to judge, I would give the edge to the defense this week.
Why?
Clearly, because I think that the expectation is this case would be over, and the judge is always right that you got to wait until the end. The case is not over, clearly, either literally or figuratively.
You know, one other thing, we talked about this on our Tubi show, but I want to talk to you about this because I'm just so interested in it that I think the prosecution played the hallway video too much. That the more you see it, the more used to it you get. And I'm not saying it's never horrifying because it is, but it's less horrifying the more you see it. And, you know, we talked about this on the show that it reminds me of the Rodney King video that I think prosecutors showed too much. I felt that way here.
The Rodney King video, you and I, by the way, another mind meld moment, we both had that same reaction because you remember that case in front of Stanley Weisberg, same judge who was in Menendez, and there were a lot, and they were all 4 officers in the state case were acquitted, and there were a lot, and hat tip to Harlan Braun, who was one of the lawyers. A lot of the pundits afterwards said exactly that, and I have had other cases over the years. I can think of one case that I had at LAX, the LAX court, where playing the video, the prosecution playing the video, and another case that I had actually, now that I'm thinking about it, downtown here at the criminal courts building, where the playing of the video and playing it so often not only numbs people, but then when you slow it down and you start to examine it, it doesn't prove what the prosecution wants to prove on the face of it. And so I don't disagree. In fact, obviously, as we already did in real time, we agree on this.
You know, it's funny. You just reminded me of something. I'd forgotten about this. Right after the Rodney King verdict and the riots, I wrote a law review article. I think for USC. And it was basically a mea culpa from me, and I felt needed to be from the rest of the media, because what we did with the Rodney King video was that there were about 13 seconds where you just see the cops beating the crap out of Rodney King. But I think the video was 91 seconds. We never showed anything but those 13 seconds. I'm guilty of that because it was the dramatic part. It's the part where you see the police abuse and everything else. And we only showed those 13 or 9 or 13 seconds over and over and over, and never showed I think there were like 71 seconds that we just never showed. And when the trial, because I covered that trial every day, and I was in the courtroom, and what the defense did in that case so effectively was they showed those 71 seconds that people hadn't seen when the cops backed off a little bit. And it was really subtle, but because they hadn't seen it, you know, the cops would back off and Rodney King would then move away from them or move toward them, which the cops said were menacing. And then they would come back at him again. And if we would have shown everything in context and people would have been used to seeing it, maybe the verdict would have been different. But because they didn't see the 71 seconds, they were way more impactful than they would have been otherwise. And maybe you could make that argument when you start picking this video apart. I don't think you can in this case, but it just reminded me of that, what I thought the media did a terrible job on, myself included, with Rodney King.
So it's an interesting, and it's far afield, but I'm going to play with it because I just thought of it. The part of what the defense of police officers always revolves around, and I've tried many of these police abuse cases, and the part of what they do is say the officer, and the law follows this. The law says the officer in a split second situation is not to be, kind of, hindsight is 2020. So that's why when you're defending, and they did it in a very effective way, obviously, because they got acquittals across the board. When you slow it down and you emphasize the fact that how can you second guess an officer in real time, blah, 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 that's very effective. What I have done in the past, and the counter argument to that is, yeah, but how many prosecutors, when they're talking about a murder case, will say, you can form premeditation, you can form deliberate decision in an instant, in a second, like that. And I've seen that used countless times in closing statements. You can form intent in a split second. So it does play both ways. But I think if I had to choose, I would always say, when you don't show the whole tape, whatever tape it may be, Rodney King, 19 out of 71 seconds or something like that, and you then let the other side play it in context, I think it's more effective, because ultimately jurors don't want to be surprised. They don't want to be misled. Your credibility in a very short, truncated period of time is to be authentic and to use your term before, warts and all, to show them that you're willing to accept the good with the bad.
Okay, last thing. You said that it's really hard to shake a juror of their opinion, even when they're seated before the trial starts. Given that video, can the defense shake them? I mean, is that video just a hill you can't climb?
You want my opinion?
Yeah.
He wouldn't. I don't think if that video was ever released, I don't think he would be prosecuted.
So do you think
I've thought about that. I've thought about that quite a bit. I mean, that's my opinion. But for that video, I don't think he'd be sitting in custody.
So do you?
I don't know. I don't know. I mean, you wanna. It's used for, all evidence. There's going to be arguments both ways. But one of the recurring themes during jury selection is, can you set that aside? It's one of the things. One of the things you do in jury selection, which a lot of people call deselection, and that's probably closer to what it is. You're trying to deselect jurors who cannot compartmentalize, who cannot set things aside. I mean, because you're never going to find in cases what I call supersized cases. The misnomer is that you're going to find people who've never heard about the case. Who believes that? I mean, how could you live in a city and not hear about a case? So let's set aside that, because I think that's apocryphal. But if somebody's being honest and says, look, I've seen it, I'm predisposed to think one way or another, and then the next question is, can you set that aside? That is some intellectual and mental gymnastics. And that's what a juror is supposed to do. A juror is supposed to say, yes, I can see it, I understand it, but I will take that, I will set it aside. And when you give me the law, Your Honor, I will apply the law to the facts. Easier said than done, as I always say.
If I were the prosecutor, you know how I would end my closing argument?
How?
I would say, ladies and gentlemen of the jury, you have seen this video from the hallway at the Intercontinental Hotel, and you have seen what Sean Combs does when he doesn't get his way. And if you believe that there was any point at which Cassie made it clear either verbally or physically, that she didn't want to participate in sex acts, in urination, in all of the horrific things you heard, if you believe that she expressed that in some way, how could you possibly not believe that Diddy would do to her there in private what you saw in the hallway?
Well, I've got an argument against that, but I'm not going to make it.
That's because you're probably working with your daughter on it.
Oh my God.
But I mean, don't you think they're going to say something like that?
Don't visit the sins of the father upon the daughter. And you know who's saying that even more than me is, well,
I know, but that's a whole. We can't get into that because I'm all fired up about the Comey thing right now. But that's the argument they're going to make, right? I mean, the prosecution. Okay. Anywho, I don't think if the judge is listening to see if Mark crossed the line, I do not think he did. So congratulations there.
Speaking of compartmentalization and setting aside, thank you, Harvey, for applying theory to practice. I appreciate that. And Your Honor, I'm trying mightily to toe the line. How's that?
I'll see you next week.
Thanks, Harvey. See you then.
See ya.